This lecture will discuss the development of the modern constitutional right to vote, particularly paying attention to the cases starting in the 1960s, which have sort of set the rules for how we litigate voting rights cases under the Constitution today. So I don't want to create the misimpression that there were no cases before the 1960s which protected voting rights. There are some significant cases, particularly under the 15th Amendment, which protected the right to vote. So that, for example, in 1915, there was this case, Gwynn versus the United States, which said that Oklahoma's grandfather clause was unconstitutional under the 15th Amendment. There were the white primary cases in the 20s, 30s, even up to 1953, which struck down a series of rules that allowed the Texas Democratic Party to limit participation in its primary elections to whites. And depending on which case you look at, those were decided to be unconstitutional either under the 14th or the 15th Amendment. And there even was a kind of quasi redistricting case right before these cases in the 1960s, Gamillion versus Lightfoot, which struck down an attempt by Tuskegee to redraw the boundaries of the city to excise almost all African Americans from the city. And that was seen as a violation of the 15th Amendment. And so these are just examples of cases where that sort of they're the exceptions that prove the rule. Because for most of this period from the Civil War up into the 1960s, the court was highly deferential to state efforts to limit the franchise and to regulate elections and voting. All of that changed in the 1960s with the one person, one vote cases, which will be discussed in a later lecture on redistricting, and the fundamental right to vote cases, beginning with Harper versus Virginia Board of Elections. The one person, one vote cases happened sort of right before this. In 1959, you have Baker versus Carr, and then you have Reynolds versus Sims a few years before, Harper versus Virginia Board of Elections. But those cases were dealing with vote dilution, malapportionment, the idea of how many people are, whether you could have districts that were unequal. Harper versus Virginia Board of Elections deals centrally with the question of whether laws that deprive people of the right to vote are constitutional or not. Given that it's not very long after Lassiter versus Northampton County, which was the case that upheld literacy tests, you might be surprised to learn that the court struck down a poll tax as being inherently unconstitutional. And so in that case, you had a Virginia law that required voters to pay $1.50 in order to vote, and actually would require that they pay back taxes for any elections that they missed. In fact, new voters had to pay it for 3 elections. While that's not a large sum today, with inflation, it would have been well over $10, $20 or so. And so the court strikes down this Virginia law requiring voters to pay $1.50 poll tax, despite the fact that the justifications for the law were very similar to the kinds of justifications that were lodged with respect to literacy tests in the case Lassiter versus Northampton County, which upheld it. So what were the justifications for this tax? Well, the first was, just like any other tax, that it was money that would be used for certain purposes, like to fund public schools. But it also had similar arguments, and you see this in the dissent in the cases. There were arguments about how the poll tax would filter out uninterested voters, that people willing to pay would have a deeper stake in the outcome. As Justice Harlan mentioned, look, we have a long history of property qualifications in the United States, so this is no different. $1.50 poll tax is no different, and it certainly seems less severe than the long history of requiring voters to have property if they were going to vote. As Justice Harlan says, people with some property have a deeper stake in community affairs and are consequently more responsible, more educated, more knowledgeable, more worthy of confidence than those without means, right? And so that the state could make that determination and therefore limit the franchise accordingly. But the case itself strikes down the poll tax under 2 rationales. The first is that it's discrimination against poor people, which would be under the suspect classification prong of equal protection. And the second is that it's a discrimination with respect to fundamental rights, in this case, voting. So let's start with the first rationale, which is the suspect classification rationale. The court says that lines drawn on the basis of wealth or property, like those of race, are traditionally disfavored. Now, You can debate that. There's certainly plenty of wealth discrimination at the time of this decision, and before and after. But the court sort of sticks its neck out there and says, well, lines drawn on the basis of wealth are traditionally disfavored, suggesting that it might be a suspect classification like race. And then, secondly, in addition to the suspect classification argument, it makes a fundamental rights argument that says that voting is a fundamental political right because it's preservative of all rights. And as a result, any infringement on voting rights must be carefully and meticulously scrutinized. Now, given the precedent up until that point, look at, we've talked about Minor versus Harper set, we've talked about Lassiter and other similar cases. How does the court wrestle with this problem that the original text of the Constitution, the original meaning, and all of history up to that point supports the idea that a state could severely limit the franchise? And what the court says in Harper is that, look, we agree, of course, with Mr. Justice Holmes that the Due Process Clause of the 14th Amendment doesn't enact Mr. Herbert Spencer's social statics. Likewise, the Equal Protection Clause is not shackled to the political theory of a particular era. In determining what lines are unconstitutionally discriminatory, we've never been confined to historic notions of equality. So there's a lot in that phrase, but the basic idea is that the meaning of the Equal Protection Clause can evolve over time. And so all of these textualist arguments that come up in Minor and come up in subsequent cases and have been lofted at the time of Harper as well as since then, that we shouldn't tie ourselves, the court says, to the original meaning of the 14th Amendment. And just as Justice Holmes in his dissent in Lochner versus New York says, look, the 14th Amendment doesn't enact social Darwinism or free market capitalism, we also shouldn't assume that the Equal Protection Clause is shackled to a particular theory that allows for disenfranchisement like this, or at least that's what the court was saying. And so this rubbed the dissenters, of course, the wrong way, and they articulate the same arguments that you saw in Lassiter and similar cases, where Justice Black says this is an attack not only on the great value of our Constitution itself, but also on the concept of a written Constitution, which is to survive through the years as originally written, unless changed through the amendment process. And so it's because the court is willing to sort of adopt this notion of evolving constitutionalism, the idea that a poll tax may have been constitutional at the time of the 14th Amendment, but no longer should be considered so, that it's willing to strike it down. The fundamental rights holding of Harper versus Virginia Board of Elections continues and is good to this day. The suspect classification holding, not so much. It's not the case that all wealth classifications are going to receive strict scrutiny and be presumptively unconstitutional. Famous case of San Antonio versus Rodriguez, which was a case dealing with sort of unequal allocation of funds with respect to schools based on local property tax receipts. That was a case that called into question this idea that wealth is a suspect classification. So that prong of Harper doesn't really survive to this day. Although I should say that rationale also was applied for, say, ballot access cases where you required that a candidate, in order to run for office, had to pay a fee. So similar concerns were raised there. But really, Harper stands for the proposition that voting is a fundamental right, and that discrimination with respect to the right to vote gets strict scrutiny. And you must carefully and meticulously scrutinize laws that deprive certain parts of the population of the right to vote. Now, you might have thought that, well, even if the right to vote is fundamental, that the particularly egregious examples of something like poll taxes or literacy tests or grandfather clauses, that's what the right to vote is about, right? That it's about these kind of classic mechanisms of disenfranchisement, particularly of African Americans in the South, but others as well. That is what the court's holding in Harper would extend to. But not long after Harper, the Supreme Court decides this case called Kramer versus Unified School District. And in that case, the state of New York required that in order to vote in school board elections, that voters had to either have children who were in the public schools, or they had to own or lease taxable real estate. And the logic there was that if you have kids in school, or if you own or lease taxable real estate, you would be primarily interested in school board elections, and so therefore they wanted to limit the right to vote to that group of people. But Mr. Kramer was a 30-year-old stockbroker who lived with his parents, so he didn't have any taxable or leasable real estate. But he apparently was really concerned about school board elections. And so the court was confronted with the question as to whether those right to vote protections that it articulated in Harper would be extended to a context like this, which doesn't sort of fit the typical, say, Jim Crow model of literacy tests, poll taxes, and similar impingements on the right to vote. And the court said that yes, the right to vote is as precious here as it was in those classic examples of disenfranchisement, that even for someone like Mr. Kramer, who wants to vote in school board elections, that the 14th Amendment's Equal Protection Clause applies to him as well. And it doesn't make a difference that he might have had the right to vote, say, for New York State Legislature, which is the one that passed this law. When it comes to voting rights, we don't subject them to majority rule. Instead, it's fundamental, and the court applied strict scrutiny, saying that only compelling interest with narrowly tailored means could justify disenfranchisement of someone like Mr. Kramer based on these characteristics. As the court articulates strict scrutiny in that case, it says the presumption of constitutionality and the approval given rational classifications and other types of enactments are based on an assumption that the institutions of state government are structured so as to represent fairly all the people. However, when the challenge to the statute is in effect a challenge of this basic assumption, the assumption can no longer serve as the basis for presuming constitutionality. It's one of the most forceful articulations of those Caroline product rationales that we talked about before. The idea that the court is there in order to intervene when the democracy is failing. And so a case like this, where a individual is in a large group of people are not able to exercise their rights in the political process, that type of law is not entitled to the same kind of judicial deference as other kinds of laws where fundamental rights are not at stake, because it cuts to the heart as to whether the democracy is functioning correctly. And so courts will take on that responsibility to check the political process when it is essentially preventing a whole group of people from participating within it. Now, I want to be clear what it means in both Harper and Kramer to say that the right to vote is fundamental and is a fundamental right under the Equal Protection Clause. It does not mean, for example, that all school boards have to be elected school boards. There's no problem if, for example, you have a system where the mayor appoints school boards, right? There's no constitutional requirement that we even have mayors, right? And as we said earlier in earlier lectures, right, there's no requirement that certain offices be elected. They could be appointed. There could be rules that sort of take them out of the political process. Take even appointing electors for president. It doesn't say that there will be a protected right to vote for president. The Supreme Court, as recently as Bush versus Gore, has said as much. What we mean when we say that the right to vote is fundamental under the Equal Protection Clause is that once a state or locality creates an elected office, that it has to treat people equally with respect to the right to vote. As Harper says, once the franchise is granted to the electorate, lines may not be drawn which are inconsistent with the Equal Protection Clause. And so while it doesn't mean that you have a constitutional right to vote for any office that you want, it means that once the state or the political body has decided that an office will be subject to election, then it has to treat the right to vote as fundamental and guarantee that it will be enforced equally. And critically, this includes groups that are not necessarily suspect classifications, right? So that so while the suspect classification prong of equal protection says that you can't discriminate on the basis of race with respect to voting rights or any other kind of government policy, when it comes to the fundamental interest prong or fundamental rights prong of equal protection, it's not just limited to suspect classes. It includes people like Mr. Kramer, right? So that if you deprive a large subset of the population of the right to vote, then you will have to justify it under strict scrutiny. You have to show that there's a compelling reason, compelling interest that's being served by that disenfranchisement. and that the means that you use, the reason that you have disenfranchised this group of people, is narrowly tailored to achieve that compelling interest. Just because voting is deemed a fundamental right under the Equal Protection Clause and strict scrutiny applies to classifications under the Equal Protection Clause doesn't mean that everybody's allowed to vote. And so while there's a kind of baseline of fundamental interest and strict scrutiny when it comes to the Equal Protection Clause and voting rights, there are certain categorical exclusions from the franchise that we just assume are allowed. So, for example, just because you might be a 16-year-old who's really interested in voting and really knows a lot about politics, it still doesn't mean that you are going to have a constitutional right to vote. And so the court has basically seen that individuals below the age of 18 are not guaranteed the right to vote under Harper or under similar kinds of justifications. Similarly, non-citizens or non-residents, what we call not bona fide residents. The court has said that in a case called Dunn versus Blumstein, that you can't require durational residency requirements, meaning that you have to be a resident for 2 years before you can vote in an election. But you can require bona fide residency requirements to say that, all right, are you actually a resident of a particular jurisdiction such that you will have voting rights? In addition, as we discussed in previous slides, previous lectures, that you can disenfranchise on the basis of felony status. Also, there are statutes on the books in most states that say you can be disenfranchised for mental competence, for example, if you're in a guardianship situation. So these are categorical exclusions from the franchise that are still allowed, despite the fact that that the Equal Protection Clause will require strict scrutiny when it comes to violations of the fundamental right to vote. So again, it's different than other kinds of rights in that we allow these sort of categorical exceptions. So even though the Equal Protection Clause protects the right to vote, voting is still highly regulated, and some people are going to be hit with burdens of election law and administration that are more severe than others. And so one of the challenges here is to figure out, well, what types of voting regulations are so severe, whether they come in the context of voter registration, voter identification, or similar regulations, that they are seen as violating the fundamental right to vote. But just to sort of keep it in your mind, there's sort of two categories of regulation. One is those that define the franchise, like felony status, literacy, poll taxes, gender, race, and the like. And then there are those types of regulations that are of the process itself that apply to the entire voting population.